Welcome to the Bar Exam Toolbox podcast. Today, as part of our Listen and Learn series, we're discussing criminal law, and specifically, the 4 mental states of intent under the Model Penal Code. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Allison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Hello, and welcome back to the Listen and Learn series from the Bar Exam Toolbox podcast. Today, we're discussing criminal law, and specifically the 4 mental states of intent under the Model Penal Code. Under the Model Penal Code, an individual is not guilty of an offense unless that individual acts with the requisite level of intent or culpability with regards to each material element of the offense. The Model Penal Code prescribes 4 levels of intent or culpability with which an individual may act. 1, purposefully, 2, knowingly, 3, recklessly, and 4, negligently. So let's go through the definition of each mental state in turn. Number 1, one acts purposefully when it is his conscious objective to engage in certain conduct and achieve a certain result. The key to spotting purposeful conduct under the Model Penal Code is looking for an individual who tries to achieve the result of his criminal conduct. For example, an individual who plans and carries out a homicide acts purposefully under the Model Penal Code definition. Number 2, the second level of criminal intent under the Model Penal Code is one who acts knowingly. One acts knowingly when he is aware that his conduct will very likely cause the result. We see here the fine distinction between purposeful conduct and knowing conduct under the Model Penal Code. Like we said, purposeful conduct involves an individual who intends a certain result. Knowing conduct involves an individual who is aware that his conduct will very likely cause a particular result. We will practice this distinction with a few hypos, but before we do that, let's finish defining the 4 Model Penal Code mental states. Number 3, as we said, the third mental state is recklessly. One acts recklessly when he consciously disregards a substantial and unjustifiable risk. And number 4, and the 4th mental state is negligently. One acts negligently when he should be aware of a substantial and unjustifiable risk, but fails to be aware of that risk. Now that we've defined the 4 levels of intent used in the Model Penal Code, let's practice distinguishing between them with a few hypos. Our first hypo. Joe is a huge football fan, and his favorite team is the Pittsburgh Steelers. Joe attends a Steelers game when they play their rivals, the Cleveland Browns, in Pittsburgh. The Steelers do not perform well during the game, and Joe consumes several beers to drown his sorrows. At the end of the game, after a terrible Steelers loss, Joe's friends ask him to leave his car at the stadium and let them drive him home. Joe is aware he's a little out of it, but he objects to the ride offers, saying, "I only live a few miles down the road, so I can probably make it home okay." Within 4 blocks of the stadium, Joe crashes into another car, severely injuring the driver. What mental state did Joe act with under the Model Penal Code? The answer is that Joe acted recklessly. Remember, one acts recklessly when he consciously disregards a substantial and unjustifiable risk. Here, the facts tell us that Joe was aware that he was a little out of it. Therefore, we can conclude that Joe was aware of a substantial and unjustifiable risk if he drove home. The risk that he could cause an accident and severely injure other people who were out on the road. We see that Joe chose to ignore that risk and drive anyway. So Joe acted recklessly by consciously disregarding a substantial and unjustifiable risk. Now, what if we change the facts slightly? Consider a variation of this hypo. This time, when Joe's friends offer to drive him home, Joe says, "I know that I shouldn't be driving, but I'd like to slam into one of those Cleveland vans on my way home. I'll be as careful as possible, but I'm not going to promise that I won't wreck any cars from Cleveland tonight." On the way home, Joe crashes into another car. What mental state did Joe act with this time? Under this variation, we must consider whether Joe acted knowingly, with awareness that his conduct will very likely cause a certain result, or purposefully, with the conscious objective to cause a certain result. The facts indicate that Joe acted knowingly. Joe told his friends that he probably shouldn't be driving. This indicates Joe's awareness that by driving home, he could cause a car accident. Joe also states that he'd like to slam into a Cleveland fan and won't promise that he won't wreck any cars from Cleveland tonight. These statements by Joe raise the question of whether he acted purposefully with the conscious objective to cause a car accident. There is probably not enough to show purposeful conduct here. Joe tells his friends that he will be as careful as possible driving home. This indicates that Joe was not trying to cause an accident. Nevertheless, he knew that he very likely could. So Joe acted knowingly or with awareness that his conduct, driving home while drunk, would very likely cause an accident. Now that we have a little practice under our belts, let's try a slightly more complicated hypo. All right, hypo number 2. Dan and Darla agree to rob a bank together. They agree that during the robbery, they will both carry toy guns that look just like real guns. Dan is in charge of gathering black clothes and masks for them to wear during the robbery. Darla is in charge of finding the toy guns. On the day of the robbery, Dan and Darla meet at a prescribed time to carry out their plan. Dan brings their black clothes and masks. Darla brings 2 real guns. Darla explains to Dan that she could not find a toy gun that looked enough like a real one to scare the bank employees into giving them money. Darla then tells Dan, "Don't worry though, there aren't any bullets in these guns." Dan and Darla put on their black clothes and masks and each take a gun. Dan does not check whether the guns have any bullets in them. During the bank robbery, Darla fires her gun in the air. A bullet leaves the gun, ricochets off the ceiling, and hits a bank teller. Turns out, Darla lied to Dan. She did put bullets in the guns. Dan is so shocked when Darla fires the gun that he runs out of the bank without taking any money. The bank teller eventually dies from the gunshot. Dan and Darla are both arrested and charged with criminal homicide in a jurisdiction that has adopted a modified version of the Model Penal Code. In the modified Model Penal Code jurisdiction, a person is guilty of criminal homicide if he purposefully, knowingly, recklessly, or negligently causes the death of another human being. The jurisdiction recognizes 3 kinds of criminal homicide: murder, manslaughter, and negligent homicide. Murder is a criminal homicide that is committed purposefully or knowingly, or a criminal homicide that is committed recklessly under circumstances manifesting extreme indifference to the value of human life. Manslaughter is a criminal homicide that is committed recklessly, or a criminal homicide which would otherwise be murder that is committed under the influence of extreme mental or emotional disturbance for which there is reasonable explanation or excuse. Negligent homicide is criminal homicide that is committed negligently. The jurisdiction also provides for accomplice liability when a person aids or agrees or attempts to aid another person in committing an offense with the purpose of promoting or facilitating the offense. At Darla's trial, she admits that she lied to Dan about whether the guns contained bullets. Specifically, she testifies, "Dan had no idea that I put bullets in the guns." Darla also swears that she didn't intend for the bullet to hit anyone. She states, "I put the bullets in the guns in case I had to fire a warning shot during the robbery. I did not want to shoot anyone. I knew that the bullet might bounce around a little bit, but there were not very many people in the bank, so the chances of the bullet hitting a person were so slim. Assuming that the jury believes Darla's testimony, what is the highest level of criminal homicide with which Darla can be convicted? So first, let's consider whether Darla committed murder. In this jurisdiction, Darla committed murder if she acted purposefully or knowingly, or she acted recklessly under circumstances manifesting extreme indifference to the value of human life. Here, Darla testified that she did not intend to kill anyone. She only meant to fire a warning shot. So we don't have sufficient facts to prove Darla acted purposefully to commit criminal homicide. And we may not even have sufficient facts to prove that Darla acted knowingly. Darla acted knowingly if she was aware that her shooting the gun at the ceiling would very likely result in a death. Here, Darla testified that she knew that the bullet could bounce around, but that there were not many people in the bank. So the chances of a bullet ricocheting off the ceiling at the perfect angle to hit and kill a person are likely not sufficient to show that Darla knew her conduct was almost certain to result in death. But Darla likely did act with the required intent for murder. Specifically, Darla acted recklessly under circumstances manifesting extreme indifference to the value of human life. Darla's conduct was reckless because she ignored the risk that firing a gun in a room with any amount of other people could result in someone being shot and killed. And Darla's conduct is likely sufficient to show extreme indifference to the value of human life. Darla admits that she knew the bullet would bounce around a little bit. So Darla likely knew that it was possible, even if not probable, that the bullet could hit someone. That is sufficient to show reckless conduct and extreme indifference to the value of human life. Given the circumstances, Darla can be convicted of murder. Now, what about Dan? Can he be convicted of murder under the jurisdiction's accomplice liability rule? Well, the answer is no. Dan cannot be convicted of murder or any level of homicide. In order to be liable for Darla's conduct, Dan must have aided or agreed to aid Darla in committing the offense with the purpose of promoting or facilitating the offense. Dan aided Darla in committing bank robbery, but Dan did not know that the guns contained bullets, and he was shocked when a bullet came out of Darla's gun. So the facts are insufficient to show that Dan aided or agreed to aid Darla in committing a homicide offense. So let's try this variation of the hypo. This time before the robbery, Darla tells Dan that she put blanks in the guns. She explains to him that she thinks it could be useful to be able to make a loud gunshot sound without the risk of actually harming anyone. Darla even encourages Dan not to be afraid to fire if he needs to scare someone. Again, unbeknownst to Dan, Darla put real bullets rather than blanks in the guns. During the robbery, Dan fires his gun at the ceiling, intending to scare everyone with the loud noise. A bullet comes out of the gun, ricochets off the ceiling, and hits a teller. The teller dies, and Dan and Darla are both charged with homicide in the same jurisdiction as above. At his trial, Dan testifies that he trusted Darla because she had never lied to him before. Dan also states, "I never would have fired the gun if I thought there was any chance Darla loaded it with real bullets. Darla has always been anti-gun violence. That is why we originally wanted to use toy guns for the robbery. I was shocked when the real bullet came out of the gun." When asked why he thought Darla lied to him, Dan said, "I think she may have been trying to set me up. About 3 years ago, Darla took the fall for me when we both robbed a convenience store. I had no idea she was still sour about it. But why else would she put real bullets in the gun and lie to me about it?" Now, what's the highest level of homicide with which Dan and Darla can be convicted? We will start with Dan. This time, Dan's conduct caused the teller's death. So we do not have to consider accomplice liability with regards to Dan. The issue now is whether Dan acted with sufficient intent to be convicted of criminal homicide. In other words, did Dan act purposefully, knowingly, recklessly, or negligently by firing the gun? Dan did not act purposefully or knowingly here. The facts tell us that Darla put real bullets in the gun unbeknownst to Dan. So we know that Dan did not fire the gun with the conscious objective of firing a real bullet and causing death. And Dan did not fire the gun with knowledge that his conduct would very likely cause a death because Dan did not know that there were bullets in his gun. It would also be difficult to show that Dan acted recklessly. Remember, Dan acted recklessly if he consciously disregarded a substantial and unjustifiable risk that his conduct would result in death. Nothing in the facts indicates that Dan had reason to distrust Darla. And at trial, Dan testified that Darla had always been very anti-gun violence. Assuming a jury believes Dan's reasons for trusting Darla, Dan was not aware of a substantial risk that his conduct could lead to death. So Dan could not consciously disregard such a risk. We should consider, however, whether Dan should have been aware of the substantial and unjustifiable risk that there were real bullets in the gun and that his conduct could lead to a death. In other words, did Dan act negligently by firing the gun? Arguably, Dan's conduct is sufficient to show negligence. Although Dan had reason to trust Darla, he also testified that she may have been trying to get back at him for a time that Darla was punished for a crime Dan and Darla committed together. And Dan could have checked the gun to make sure it did not contain real bullets before the robbery. Whether Dan acted negligently or not, by doing so, under the circumstances, is likely a jury call. But negligent homicide is the highest degree of criminal homicide with which Dan could be convicted. So, let's finish up with Darla. Can Darla be convicted of criminal homicide under this variation of the facts? Assuming that a jury concludes that Dan is guilty of negligent homicide, Darla could be convicted of negligent homicide as an accomplice. As we said, this jurisdiction provides for accomplice liability when a person aids another person in committing an offense with the purpose of promoting or facilitating the offense. Here, Darla aided Dan in committing negligent homicide by providing him with a loaded gun and telling him that the gun only contained blanks. The issue is whether Darla acted with the purpose of promoting or facilitating Dan's negligent homicide. Arguably, she did. By lying to Dan about whether the guns contained bullets, Darla created a situation in which Dan was more likely to fire the gun. Darla also told Dan that the guns contained blanks. And she encouraged him not to be afraid to fire the gun and scare someone if he needed to do so. Darla's encouragement of Dan to fire the gun supports Dan's theory that she was trying to set him up. Like with Dan's conduct here, whether Darla acted with the purpose to facilitate Dan's commission of negligent homicide is likely a jury issue. But negligent homicide would be the highest degree of criminal homicide with which either Dan or Darla could be convicted. And that wraps up our discussion of the 4 levels of intent under the Model Penal Code. Hopefully you found these hypos helpful examples of how to work through a Model Penal Code intent question on the bar exam. If you enjoyed this episode of the Bar Exam Toolbox, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to Lee or Allison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.